Resuming debate, the honourable member for Vancouver Quadra.
Thank you, Mr. Speaker, and I'm happy to be able to join my colleagues speaking so eloquently on behalf of equality for those who serve Canadians in the military, and the gaps in this particular bill that is purported to update our military justice, criminal justice system, but in fact has some significant gaps. So it is always good to review our laws and make sure that they are reflective of the present realities, that they are equitable, that they are appropriate, and that they're consistent with the law and our Constitution of Canada. And of course, the military criminal justice system is no exception. This bill has been worked on for a long time, but it is not where it needs to be for our party, the Liberal Party of Canada, to support it. And the members from Winnipeg North, from Halifax West, from York West have made that case in a way that has been quite specific and quite compelling. So I just, Mr. Speaker, the fact that we're being asked to support something that still has so many flaws in it that's politics, but c'est clair que de nombreux aspects du système de justice militaire demeurent inexplicablement inchangés ou conférant des pouvoirs inutiles dans ce projet de loi. Par exemple, ce projet de loi inscrit dans la loi une liste d'infractions militaires qui seront désormais passibles d'un casier judiciaire, sans que ce soit vraiment nécessaire dans certains cas. Le système de réhabilitation ayant été révoqué récemment et le procès sommaire étant ce qu'ils sont, pas d'enregistrement, pas de possibilité de véritable appel, les membres des forces armées se retrouveront avec un casier judiciaire et seront incapables de trouver un emploi au moment de leur libération. So clearly there are some flaws in this bill. But the one that I want to focus on in particular is the issue of human rights and equality. And that really boils down to what kind of a society do we want to have in Canada. And I think Canadians are clear. The Charter of Human Rights and Freedoms in Canada is widely supported right across the country and a very proud part of our framework of protecting rights, but also enshrining responsibilities in our country to make sure that those who are less vulnerable have the law on their side to protect their right to equality. It has been shameful and disappointing, I think, that the Conservative Party of Canada has chosen to minimize the importance of this very important part of our Constitution, the Charter of Human Rights and Freedoms, and essentially dismissing and not celebrating its great anniversaries. Last year was the 30th anniversary, and not much of a murmur from this government, but hundreds of millions of dollars go into celebrating the anniversary of a war. So that goes down to what kind of society do we want to have? Do we want to have one that protects rights and freedoms, or do we want to have one that is all about punishment? And we see in changes to immigration, we see in Bill C-10, that grab bag of bad public policy, that the Conservative government is much more focused on punishment than it is on equality. And that is reflected in this bill as well. So as the retired colonel that my colleague referred to previously, Michel Drapeau, a fait remarquer lors de son témoignage devant la comité, un accusé dans un procès sommaire n'a pas le droit d'en appeler ni du verdict ni de la peine. Et cela, même si la sentence et la peine sont imposées sans égard aux normes minimales relatives aux droits des accusés dans une procédure criminelle, par exemple, le droit d'un avocat, la présence de règles de la preuve et le droit d'appel. Au Canada, ces droits sont inexistants dans un procès sommaire, même si l'accusé est un ancien combattant décoré. Pourtant, tout Canadien accusé d'une infraction punissable par procédure sommaire ou au civil, à l'instar jouit de tous ses droits, de même que toute personne qui comparaît devant un tribunal des petites créances ou un tribunal des contraventions routières. So, and he goes on to say, il me semble très étrange que ceux et celles qui risquent leur vie pour protéger les droits des Canadiens soient eux-mêmes privés des droits que leur confère la Charte lorsqu'ils font l'objet d'une procédure quasi pénale avec la possibilité de perdre leur liberté s'ils sont placés en détention dans un baraquement militaire. So clear questions of inequality have risen here. There are problems with this bill that are fundamental to the kind of society that we want to have, not just a few tweaks that we could have put into this bill and that the government hasn't done. This does go down to fundamentally what kind of a society we want to have. And this is kind of inequality is being unfortunately cemented in other bills, in other laws brought forward by this Conservative government. And I want to just refer to some comments that were made by my colleague from Mount Royal recently on the occasion of the anniversary of our 31st anniversary of the Charter of Human Rights and Freedoms. But before I do that, there's Judge Letourneau was very eloquent in talking about that les soldats sont des citoyens et devraient jouir des mêmes droits constitutionnels garantis par la Charte que tout autre citoyen. And this is what he said, Mr. Speaker, en tant que société, nous avons oublié, et cela a de grandes conséquences sur les membres des forces armées, qu'un soldat est d'abord et avant tout un citoyen canadien en uniforme. In other words, should be able to count on all of the rights and protections that citizens enjoy in our country. So, Mr. Speaker, referring to our Charter of Human Rights and Freedoms, the member from Mount Royal raised a question of privilege in the House this past March and expressed concern that the government is failing to live up to its own statutory obligation which is expressed in Section 4.1 of the Department of Justice Act. And, Mr. Speaker, this is in law. This is requiring that the Minister of Justice examine each and every government bill introduced in the House to ensure that it is consistent with the Charter. Now, that would seem like a simple step to respect our fundamental constitutional obligations as parliamentarians and as government in lawmaking and public policy making. So how often has the government actually done that? How often has the government checked and done a review to ensure that its bills introduced in the House are consistent with the Charter and receive the constitutional seal of approval? How often has the government reported any inconsistencies or otherwise, such as that, to the House? Anybody have an answer to that question? Well, Never. That's right. My colleagues are on the ball here. So no such report has ever been tabled by the Minister of Justice. So this is not just a procedural rule. This is actually fundamental to protecting our rights and freedoms that are engraved in our country's framework for justice. So why has this government never actually done that kind of a review? And what is the consequence of that? Well, actually, the consequence is very expensive because that means the government continually comes forward with bills that are then contested either at the provincial level or through other organizations. That ties up court time. That ties up resources. For example, there are challenges now to government's other bills, and I think that there are very likely to be a challenge to this bill that we are debating today because of this government not just omitting an important part of our equality framework from this bill, disadvantaging our troops, our Canadian Armed Forces, whom we all respect and would want to see treated equally. So, Mr. Speaker, I think there may well be a challenge to this bill, not just that it's flawed, but it will then go through the hoops of being contested and found failing. So let's avoid that. Let's pull this bill back. Let's fix it before it goes forward on behalf of Canadians, on behalf of rights and equality, and on behalf of our armed forces.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of National Defence.
Thank you, Mr. Speaker. Mr. Speaker, I have to begin by saying that many of us on this side of the House and in the government benches are taken aback by the member's speeches and the other speeches we've had today from the Liberal Party, because while the member for Vancouver Quadra may have prided herself on running a leadership campaign that was pretty far to the left, many of her proposals today actually are more extreme than those proposed by the NDP in committee or at any other stage of this debate. And so my question, Mr. Speaker, is if she thinks the summary trial system is unconstitutional, does not cohere with the Charter, then why didn't the Liberal Party do something about that during the 15 years that they were in government under a Charter and with this military justice system? Secondly, Mr. Speaker, why were these points not raised in committee by the Liberal Party? Why are we suddenly at report stage hearing these radical musings from Liberal members about our military justice system, which never came up in committee? Secondly, why are they relying on only 2 witnesses? 2 witnesses that took extreme positions, Mr. Speaker? Why are they delaying necessary changes, modernization, updating the military justice system? And finally, Mr. Speaker, why don't they take pride in a military justice system which, as part of our larger justice system, is the envy of the world? Thank you, Mr. Speaker.
The Honourable Member for Vancouver Quadra.
Well, thank you. I find it actually amusing that that the member opposite is using words like radical and extreme for a proposition that the Liberals are making that, in fact, was applied by the British Parliament. And we have a Conservative government in Britain. So the British government did actually go a long way to ensuring the fair treatment of soldiers facing summary trials. And in Britain, I would claim that the requirements of independence, impartiality, fairness, equality are very similar to those in Canada. So if we are proposing that this law actually, before becoming law, should incorporate those kind of changes that have been incorporated in Britain and so many other places, I fail to understand how this can be considered radical and extreme proposals.
Questions and comments? The Honourable Member for Scarborough Southwest.
Thank you, Mr. Speaker. And I rise after the member's speech in reference to the member saying that the Liberal caucus was on the ball. And I'd have to say it's a little late to come to this on the ball. When we had the Liberals at second reading and report stage, they only had 1 speaker at each of those stages. Furthermore, the Liberal Party never made any recommendations for amendments at committee. And now the member is saying we have to incorporate these changes into the legislation before we adopt it. Well, the place to do that is in committee to actually make proposals, which the NDP did. We did make recommendations at committee to actually make amendments to this bill to make it better. And I would like to ask the member why, A, the Liberals didn't send up more speakers at previous stages of this bill. B, why they did not recommend these changes or any changes to the bill at committee, and why they didn't support the NDP amendments.
The Honourable Member for Vancouver Quadra.
Well, thank you. And clearly the member from the NDP prefers process over principle. I think this is about principle. And the quantity of amendments brought forward to committee, is this member saying that committees are an absolutely ironclad place to do great public policy? Are amendments actually happening in committees these days? Does this member feel that a committee is a place that he and his party can actually get great public policy to happen? Well, I would posit that that is not the case. And so to rest a decision based on the process of committee rather than the fundamental principle of human rights and equality is not one that I agree with.
Questions and comments? The Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I thank my friend from Vancouver Quadra. It related to the comment that was just made by a member from the official opposition. We still have time to amend this legislation. I've put forward amendments that would preserve the independence of the investigations and prevent the senior military officials from interfering in the scope of an investigation. It is exactly our opportunity to pass those amendments today. And I would be very grateful if the official opposition and the Liberal Party would change their current position of allowing this vote to go by division and instead support a vote on these amendments to improve C-15.
The honourable member for Vancouver Quadra, short answer, please.
Well, thank you to the member from Saanich and the Islands, and I'm glad to see the member bringing forward a question of process to support a principle rather than a question of process to undermine a principle, as we heard from the NDP. So thank you for that intervention.
Resuming debate, the honourable member.